I think I was 1 second early tonight, people. Okay, let me make sure everything is good. I just got a warning that said my internet connection was bad. Okay. Geez Louise, are we 2,000 people watching already? Okay, two things first before we get started. How is my audio? No F's as a joke, or do the F's as a joke, but I'm going to disregard them. I put a different this thingy on the thingy mic, so maybe there'll be less pop or less breathing, as I was told my audio was in a previous stream. So that's good. And also, I think it's a little less distracting. You can see the anti-media right here. Yeah, this is going to be amazing. I mean, we could not do a stream. This is sort of like the stream that we did when there were certain events surrounding the election, which we are no longer allowed to refer to. Yeah, people need to understand what happened today. We need to go over, express some of our thoughts. Yeah, this has been a masterclass of sorts of the legal profession, of the legal practice. And everybody should have gotten to watch as much as they could. I mean, I appreciate it's all day for however many weeks. It's not feasible for people with regular jobs to keep up with this. But for anyone who was thinking of getting into law, for anyone with a curious mind who wants to make sure they understand really what's going on and not just what they're being told is going on, this was a must watch. So today, let's see, here we go. Viva, let's bring up a couple of chats. I like how you wouldn't do a coverage stream and then let Nate take the copyright strike. Oh, Goochman, I told Nate. So first of all, there's two reasons. I don't like reaction streams. I don't like them just in general because you end up invariably talking over that which you want to react to. And so it makes it difficult it's not like you can pause and then react. I would do one, after the fact. But I'm also once bitten, twice shy type thing. I know it's public domain. The stream of the court proceedings is public domain. I know YouTube. And when you are streaming, when you are sharing someone else's stream, even if it's public domain, there could be an argument in there that YouTube could say, if I share to live react Fox News's live stream, for example, I'm taking traffic away from Fox News's streaming of the public domain event, and it's got their, avatar logo on it. So there could be something of a claim that YouTube says you are doing something of a deceitful practice by live reacting to another stream on another platform, thus siphoning traffic from them for the purposes of your stream. I think it's bullcrap, but I can easily see it happening. And I was very open with Nate. I said, I don't want to do it. If you do it, I might pop in. I didn't actually say that, but I said, I'm not doing it on my channel. I don't want to take the chance ripping what off. I don't know where the original source was, but ultimately I wanted to watch it. I didn't mind commenting. I was live chatting on Nate's stream, but I enjoy watching it without the interruption so you can actually hear it. Let's see what we got here. John says, well, my work night just got a whole lot better. Good people rely on your commentary and analysis. Keep up the good work, fellas. Thank you very much, John. And I think I missed another super chat, which was Bamboonga says, you missed my 9th super chat. The real Bamboonga, how you doing? And I did miss one, I think. No, I didn't. It's not the bottom. So I think I should be able to get to as many super chats as possible here. A lot of F's in the house. Jeez Louise. And then you know what happens? Like what happened on Richard Barris. There's an actual audio issue and everyone thinks you're joking. Okay, what do we got here? Angry Bellsprout says, think one of these days Viva will find out about the super chat tab so he can't claim he lost them. I don't know what that is, but no, the super chat tab doesn't work because I'm through StreamYard. So I can't, like, what's the word? Gather or collect the super chats in StreamYard, and then I have to have two windows open. And I'm on my computer. So it's, I'm running a one-man operation in a basement. This is literally like pump up the volume. And with what's going on in the world today, it feels like pump up the volume law version. Except I'm a lot shorter. Maybe I'm not shorter than Christian Slater. I'm not as good looking as Christian Slater was in his prime. Viva Fry, the F's were because your stream died for a minute. Oh, are we back? Okay, so now Robert is in the house. So if I miss your super chats, don't be miffed. 30% goes to YouTube, no legal advice, yada, yada, yada. Let's break down these closing arguments. We summarized the trial last week. Closing arguments today. Robert, how you doing?
Good. I don't think anyone's going to really remember these closing arguments. They were nothing at the level of if the glove doesn't fit, you must acquit, which we remember almost 30 years later. It's not near, Jerry Spence. If the lion got away, Kerr McGee must pay in the great Silkwood case in Oklahoma. It's not William Jennings Bryan in the Scopes trial. I'm not concerned, Mr. Darrow, with the ages of rocks. I'm only concerned with the rock of ages. By the way, he won that case, despite what the left has made of it later. So they should have flipped. Well, we can get into it further detailed. Here's the summary of the prosecution. Today, ladies and gentlemen of the jury, you get to be the mob. So get that lynch rope ready, because this is a legalized lynching. Be the mob. They couldn't do it that day, but you can. And the defense was the same thing it's been all the way through, which was a technical facts and law presentation, and maybe that demeanor and disposition will work, raising questions of reasonable doubt. And then the rebuttal had a couple of good catchphrases. The general theme was believe your eyes, which really meant believe the media's lies.
Well, this is the thing. So they had their catchphrases. Actually, back up to the straight beginning here. Yeah, nothing memorable, but in the sense where this is the dream team on steroids of law. This outside
on the prosecution side,
on the prosecution, and it was not just that there was nothing catchy. There was nothing that you would remember. Nothing that captured an image. It started off so slow, and I'm talking. I don't want to use words like cliched, but it started off with such overuse of dramatic effect that if I'm on the jury, I might feel that it somewhat cheapens actually what is at issue here. And instead of going for the facts and going for the meat of the issue, you're trying to make me feel bad in the most cheap and exaggerated ways. And it went on for a long time. And a lot of people were saying, like, this is private counsel, the dream team, and this is how it's starting, like with we say a pétard in French, like a wet firecracker, and saying things like "trust your eyes." And the biggest problem I have, I'm in the Nate's chat. I say, "Trust my eyes." My eyes wouldn't tell me, drug levels. My eyes wouldn't tell me heart conditions. My eyes wouldn't tell me a lot of things that might be even more relevant than my eyes. And so I thought it falsified.
As the defense pointed out, the MMA fighter believed his eyes, and he thought there was a blood choke happening, and it wasn't. Somebody else believed their eyes, and they thought a respiratory choke was happening, and it wasn't. Other people believed their eyes and saw things that just weren't the case. And so I didn't think, but I took it as a broader message of, hey, you came in here, we the community, they used the crowd as the substitute for that. The community wants justice. You're going to deliver it for them. Believe all the media hype you believed coming into this case, and disregard everything else. And that's why I say the believe the eyes meant believe the media's lies, was how I interpreted the only real thematic unity of the prosecution's case. Now, the rebuttal had a couple of good lines that he bookended. Always good to use bookending, which means you finish your case the way you started your case. And he started his case with, in your custody means in your care, and the badge is authority, and it's also responsibility. He came back to the badge. He came back to that phrase. He had a closing line that was supposed to be Johnny Cochran-esque. It was just a little risque. One of our magical meme makers on our locals board, Viva, barneslaw.locals.com.
And who's the meme maker? Is it Talex?
It is, of course, Talex. He basically put the Grinch on Chauvin's face when he's on the famous photo of Chauvin on Floyd. He just substituted the Grinch's face because of the closing line was that George Floyd didn't die because his heart was too big. George Floyd died because Derek Chauvin's heart was too small. And that will be the media line. Well, probably the most quoted line from the closings by the press. But, if he had set it up better, if he'd done it a little better, maybe that sticks. I get why he thought it was good, but it was just it's one of those things that sounds great. I'll give an example. For years, a buddy of mine that was a criminal tax defense lawyer used to say, look, a lot of people used to believe in Santa Claus too. And he was pointing out that a lot of people believe a lot of things about the world that turn out to be untrue. And he was arguing his client believed something unique about the tax laws because of the similar logic of disbelieving Santa Claus. He quit using it when a prosecutor came up with a rebuttal which is, oh yeah, his client thought he'd found his own personal Santa Claus that allowed him not to pay taxes anymore. Wasn't that a wonderful Santa Claus? So he's like, oh, got to drop that one. So that's where you got to be careful with those. You got to be smart with them. I mean, if the glove doesn't fit, you must acquit was genius.
Well, it was, I say, genius, catchy, but directly related to the evidence and not like a Twitter
and
jab.
visual. One of the biggest visual pieces of the evidence that the gloves actually didn't fit. That's what happens when you drop evidence and try to frame somebody, Mark Furman. But that's another story for another day.
Someone said we're never going to have the O.J. Simpson because we've been teasing it for a while. I think when we do it, we have to have Dershowitz on at the same time if he's open for it.
Dershowitz would have done a much better close. I mean, I understand where Nelson's. If I'd been doing the close, I would have had that the jury, ready to hang him by before lunch. There was so much emotionally packed information here that you could tell well, not play to the cheap seats, but just build that emotion effectively.
Well, that's the problem, is that it is emotion done properly is good. Emotion done improperly looks exploitive and it looks cheap and it looks, maybe tawdry is not the word. I'm flashing to Family Guy here, but what he did looked like, first of all, it strawmanned the individual. And this is the problem that I had listening to it, and that everybody knows now. Look, you don't need to portray George Floyd as a saint in order to portray him as a victim that day. And they went back to doing that in such a way that, that he was about community, and that he was just a member of the community, participating in an active way, straw manning the victim of George Floyd, where they didn't need to, in order to properly portray him as a victim on that day. And I think it would come off as bad if I'm sitting there. It didn't make, and I'm an emotional guy. I will cry during television ads, literally, during songs, or during music. It didn't even strike that in me, and it made me feel dirty that they were trying to trick me, as opposed to actually just make me appreciate that he was a victim that day, notwithstanding the fact that he was not a saint in his life. So they strawmanned on the beginning and the end. That was the bookending part that I had, is that they strawmanned at the beginning and Blackwell strawmanned at the end, as far as I'm concerned.
I only cry when I see his fraudulency as the president. But I mean, I thought that they had so much they could use, so much time to prepare, such a huge team. I was very underwhelmed, and I was watching other lawyers on TV do their response, and most of these lawyers want convictions, and their response was the same. They were like, well, in fact, one of them said the best way you can describe the prosecution's opening statement is it was both unreasonable and excessive, playing on the unreasonable and excessive force phrase. That you don't want that to be the interpretation. So the closing arguments definitely didn't help a lot. The rebuttal they should have reversed the order. The guy who went first is a good rebuttal guy. He's a longtime federal prosecutor, now in corporate private practice. One, those guys don't actually do a lot of trials. People don't realize that about them. But number one. Number two, they have such massive institutional advantages that they win almost all the time. And whenever they lose, they think it's coincidence, or they think it's random chance. I mean, these are people who truly were born on third base, ended up on second base, and think they hit a double. I mean, that's who they are. But the second guy would have been much better being the first guy, because he's the better narrator. This was true throughout the whole trial. He was better at direct, bad at cross. The other guy, bad at direct, good at cross. So that's the pattern they should have maintained. But my guess is, knowing the ego of Attorney Blackwell, that he wanted to go last. They made the same mistake in the Snipes case. The great attorney, prosecutor Bobby O'Neill, who was the U.S. attorney for the Middle District of Florida, had been trained by the man made famous in Law and Order in New York. He demanded to go last too. And I think it was because he wanted to go first and go last. And he was very complimentary of me after I finished my close. And then he made some mistakes in rebuttal. He was never a great rebuttal guy. He was a great go first guy. But they think going last really matters. Not in my view. I think
the rebuttal, I didn't think made any real.
It just made the judge mad and created another mistrial risk.
Well, okay, hold on. Actually, before we get there, let me just read this, because this is funny. I've been thinking about this chat since I read it. A request from a friend, Viva. If you can translate in French, a green worm pours a glass towards a glassmaker around 8 o'clock. Un verre vers un verre vers un fabriqueur de verre vers 8 heures. Vers 20 heures. I see that one. Okay, that's funny. Hardy heart. Thank you very much, by the way. Yeah, what was it? So let's do what was the deal with the mistrial towards the end? I mean, what happened there?
So what happened was this was a risk of bringing in a big famous civil rights trial lawyer like Blackwell. Blackwell's used to civil cases where he probably gets away with a lot of stuff. Probably tries them in front of a lot of friendly judges would be my guess. Don't know that, but that'd be my guess. And they're accustomed that you can say a lot of stuff in civil trials that you cannot as a prosecutor in a criminal trial. Not only can you not comment on the defense asserting the fifth, which they tried to do, by the way, they try to get advance permission for that on the lamest of grounds. I mean, that would have been a huge, huge appellate risk. It tells you how nervous they are about potential acquittals in this case, that they were even willing to gamble like that. But what you cannot do as a prosecutor is you cannot comment on the criminal defense lawyer. So, you can comment on the arguments, but you cannot say anything about, and he couldn't help himself.
He kept on saying, when people have to appreciate this also, whenever you get into the practice of law, it does no good referring to the opposing counsel as dishonest, suggesting dishonesty, bad faith. It does no good. Everybody does it as a rule because they think, the truth lies in the power lies in the accusation, maybe on social media, but not in front of a judge. And I noticed he kept on doing it. I said, you're to say something is not true or contradicted or disproven is one thing. To say it's dishonest is another. Sorry, I cut you off.
No, that's exactly right. And it made the judge mad. The judge, if you want to see a judge enraged, even when he's, his whole face is covered with a mask, just look at his eyes after Blackwell did it for like the 11th time. He came up with this, there's a stories, which I wouldn't have used the imagery of stories anyway. But he's like, their defense is just coming up with stories. And then when he got hammered, when the judge sort of sua sponte said no more reference to stories because of what it was inferring, he came back and said, okay, fabricated facts, which was worse. It's worse. Completely. So it will be a good appeal issue. It definitely was prosecutorial misconduct. Now, they almost never reverse on those grounds, but they're starting to build a cumulative case here. Venue issues, failure to sequester. They did try to get a mistrial on grounds of the failure to sequester related to Mad Max. The judge made some very negative comments about Maxine Waters, said, I wish these politicians, said, one, you may have a very good argument on appeal for this. Put that right up there, right up front. And secondly, said that I wish these politicians would shut up, which not long thereafter, apparently the governor of the state of Minnesota came out and said the future of the state is in the hands of this jury and went on this whole tirade. It's unbelievable.
They can't help themselves because we live in an era of social media politics where people have to do it for the immediate satisfaction, the immediate brownie points, the immediate support it gets from our base. It's an amazing thing. This would not be the case 20 years ago, 10 years ago even, and now it's an unavoidable reality. So he kept the stories to fabricated facts or whatever the word he used, went from bad to worse. In civil law, it happens all the time. It's the repartee of the court, and it's no more serious than that. But
it's a big issue. It's violated plain law from the Minnesota Supreme Court, and the only people who seem to lie overtly in the case was about jury instructions, which was the prosecutor saying that the defense did lose a key argument about intent related to felony murder.
Yeah,
but he went up there and said, to have intent of third-degree assault, you don't even have to intend to cause any harm. Well, that's patently false. The definition says intent to cause bodily harm, or the fear of bodily harm. And so the way he put it, I was like, that's just completely. Put it this way: if you get an AWOL verdict, like conviction on felony murder and acquittals on the lesser charges, then it will pose the issue right up to the Minnesota Supreme Court of the problem with the current law in Minnesota.
This, I won't call it a beef between you and Nate. It's a disagreement on law. And I think it's actually just a disagreement on argument, not on law, in that I think we agree on what felony murder in Minnesota means. The argument is just that it doesn't make sense because even by Nate and uncivil laws analysis, they think it's more likely to get a conviction on the stricter 40 years felony murder than on manslaughter, because the conditions are met for that, which doesn't make any sense on a constitutional practical law level. So
it's why Dershowitz says it will be overturned on appeal, especially if they convict on that and not the others.
Yeah.
Now, I don't think that they will. the background on the felony murder component is that what the defense requested was a fourth element, which is the Minnesota Supreme Court in 2003 said felony murder has to impose a special risk to human life. And it has to be inherent in the statute itself and in the facts of the underlying case. Good Logic actually has made this point in a couple of contexts. It's a bifurcated function. So he wanted it added as an element of the offense, which there's a good argument for. The judge decided not to add it to it because he didn't want to deviate from the model instructions, but the model instructions haven't dealt with that Supreme Court decision very effectively. So now he's really teed up the case perfectly because there is no precedent in Minnesota for a fact scenario like this, particularly when you add in it's a cop excessive force case. So, for example, it's very smart by Nelson, the defense counsel. He conflated all the intent elements together. Like Dan Abrams was being critical. He's like, oh, no, I didn't talk a lot more about intent and saying you could do lesser here and there. This is why. Because the intent element is kind of vague as it relates to felony murder without that added element that they wanted. Now, what it did say was intentional, unlawful bodily harm as assault. So that would at least appear to the jury to sound like Chauvin must subjectively know that he was engaged in excessive, very dangerous force, which what that does is that reincorporates the intent standard from the other elements back into it in a backdoor method if the jury interprets it that way. And that's what Nelson did, drove the prosecutors nuts. They wanted to take shots at it. And they were like, judges wasn't hearing it. He's like, I'll give the general instruction, ignore lawyers.
So, yeah, now, actually, that was my first question. What do you think of the judge's instructions? Everyone should know, I've never practiced criminal law. I have no direct or professional experience with this. I heard them. I thought the instructions were fine. I thought they were a little bit legally complicated for jury members. But what did you think of the instructions? Were they so they were not tailor fit for this case? Were there any problems with them, or are they par for the course?
I think not from a conventional perspective, that he stuck pretty close to the model instructions. And the reason why a lot of judges do that is because it reduces their appellate risk. But here, there's such big legal issues with both second and third degree murder. He could have mitigated that risk by modifying the instructions, and he did not. And so they're like, in the second degree murder issue, it's how does felony murder play out in this particular factual context where you have a merger of the crimes, where the only crime is the underlying crime, where you have an officer use of force issue involved. There's no precedent to my knowledge on that set of facts in Minnesota.
And even on the underlying felony murder, even the precedent that some people were referencing did not have the assault leading to the death as the underlying felony. It was burglary, which led to the death, which was the underlying felony, which was a distinct felony from the act which directly led to the death, which is seemingly unique to this case, even more unique in that it's coming from an officer. So the assault itself, in order to be the assault, has to be excessive force, which is one of the points we're going to get into in a second. I'm just taking notes. But
so if he had added the special danger to human life element, he could have mitigated the risk of this statute's application in this context. His failure to do so, especially given the arguments the prosecutor made, that the prosecutor was able to try to interpret the jury instructions to mean you can be convicted of murder in Minnesota without intending to harm anyone. That was I get he was taking a gamble with that. Again, that shows their nervousness. But if I was doing the appeal for Chauvin, that would be right up in paragraph 1, because it shows people are like, what? That doesn't make sense. So that's issue 1. Issue 2 is on third degree murder, which again, this was a judge who didn't think it applied here anyway. Court of Appeals reinstated it, but it hasn't gone to the Minnesota Supreme Court. There, the problem is highlighted by instructions too, because the statute uses the word eminently dangerous to others. And historically in Minnesota, that had been interpreted going back over a century as meaning multiple people. And he could have tried to salvage that by including that kind of language. He did not. So his jury instructions highlighted rather than diminished the appellate issues as to those two charges. I think he did a favor on intentional, but I don't think the prosecutors caught it by saying that intent required it be that there be an intent to the act for the action to be unlawful. And maybe he meant to say unlawful is a separate objective element, but it's right in the definition of intent. Nelson read right from it. Jury's going to see it. Now, my own view of jury instructions is they rarely matter to juries.
Okay, I was going to get to that. I'm going to read this one here. It says, I've learned so much about law just watching you guys over the past year. Thank you so much for what you do. Thank you very much. And then Tom Villas, we're going to get into the jury not really listening to the jury instructions, I suspect, and then answer this question. Sorry, what can we expect the jurors are likely to be doing over the next 48 hours? So I mean, explain. The juries are sitting there listening to this legalese coming from a judge as to how they're going to deliberate. I imagine by and large, they have an idea as to where they're going to go, and it's going to be a debate among all of them for the next one. Are they now deliberating, or do they stop at a certain time of night?
They usually stop at a certain time of night. So they probably in a half an hour or so they'll stop. And they didn't come right back. It's always a bad sign when they come back in an hour. I remember telling a client once that it's like, well, if they come back in an hour and then we were 45 minutes out and then the bailiff came back. I'm like, well, kind of screwed. Now's the time to run if you can. I didn't say that. It's completely sequestered. They're not even allowed to have their phones, their tablets, or their computers. So they have zero access to the outside world. They're allowed to call a phone call from the hotel to their family, and that's it. So this is they're fully sequestered. My understanding is it's going to be like 9 a.m. to 6 p.m. Sometimes it can go longer. Jury deliberations each day at the courthouse, and then they go back to the hotel. My hunch. So it all depends on the jury. They usually select the 4-person first.
Do we know who the jury 4-person is?
Yep. And sometimes we'll know if they ask a question. So because what it is they'll decide on a question, they'll give it to the bailiff. The bailiff will go in, ask the judge. The judge will bring in the lawyers, say, how do we answer this? Do we answer this? So on and so forth. And sometimes they'll ask for specific exhibits and specific evidence. People ask whether they have access to transcripts. They do not. They also do not have access to a lot of the demonstrative exhibits used throughout the case. They only have access to evidence that's actually been admitted into the court proceeding. So the videos, the audio, the underlying documents. They can ask for testimony to be read back to them, but not for transcript.
Are they allowed taking notes and consulting their notes at any point, or no notes whatsoever?
With this court, yes. So it all depends on the judge. Some judges allow it, some judges don't. They increasingly allow notes to be taken, and they are allowed to look back at their notes, but they're supposed to rely upon their recollection rather than their note taking. But that's up to them. And then, how each jury is different. Some jurors sit there and say, before we discuss anything, let's go through all the facts. Let's go through the jury instructions again. Let's figure out what we're doing. Let's pick a 4-person. Some take a vote right away. Some do the vote privately. Some do the vote publicly. So there's no set rules on how they behave back there other than they have to do it in secret and basically do it from 9 a.m. to 6 p.m. or thereabouts.
Do we know who the jury 4-person is yet or not yet?
Not yet.
Okay.
So now, and usually that's a big tell. If it's that young social media person who is all excited about being on the case, Chauvin better get ready for conviction. If it's the older woman that's in a nonprofit, better get ready probably for conviction. Not as high. If it's one of the African American men, or if it's the IT guy, then the Chauvin's in the game. That would be my
How are they going to identify who the jury 4-person is? Is it by number, and we're going to have referenced the numbers as to who the jury members are by identity?
In terms of publicly, yes.
Okay.
So I presume sometimes we don't know until later, though because of the uniqueness here that we don't have access to the jury, that they're still staying anonymous despite media efforts apparently to already start doxing them. So, I mean, this is the craziest case ever from that perspective.
Well, it was crazy. I mean, what's crazy? I mean, we saw the case in Rittenhouse where they're doxing donors and showing pictures of their houses and posting that on the media. Okay, now I took some notes, beautiful notes, on some issues that I had. Now, I'll preface this. I've said it before and I take some flack for it, but I'm not saying this so that I'm trying to convince anybody. I'm saying this so that you can understand where I'm coming from. From the beginning, I thought Chauvin did something very wrong. From the beginning, looking at Chauvin the way he was kneeling on him, I saw someone who did not have a care in the world about the individual. This is what I saw in the image, what I saw in the video, which was only part of what I now know exists, given what we have seen come out of this by way of evidence. So that's what I think from the beginning. And I say this as someone who thought that from the beginning and might stubbornly still think it now. Having seen what I've seen, I can see how someone can have not a far-fetched, frivolous doubt, but a real, reasonable doubt. And I can see now someone looking at Chauvin after Nelson's closing statements and look at him and saying, this is not someone who doesn't care. This is someone who's feigning authority to try to keep a situation calm, doing what he thinks he's been trained to do. I can see how someone can see that, even if I still don't see that myself. What I noticed in their closing arguments, specifically mischaracterization, straw manning, when they went to the homicide on the death certificate, and they said, and they used the legal definition of homicide, when, as far as I can recollect, their own expert said homicide is not a legal term on, what's the word I'm looking for, Robert? The death certificate.
Yeah, the death certificate.
Okay, so their expert, unless I'm mistaken, said homicide is not used in that sense. It is used in the purely neutral sense that this was a death in virtue of which another human had a role, not homicide as in murder sense. And unless I'm mistaken, they went back to that and tried to mischaracterize or try to strawman the use of the homicide in the death certificate to mean what their expert said it did not mean. Am I wrong with that, or is that a adequate understanding?
Yeah, I mean, they took a lot of, I mean, their core of their prosecutorial theory, to the degree you could say it had a thematic unity, was very much 4 seconds. Remember the photo. Remember the 4 seconds. Yeah, based on that, convict. And in order to do so, the prosecutor, as you know, made a big deal out of a homicide declaration that really wasn't, in terms of the law, and it had no real quite the same bearing they wanted to apply. The only dispute was whether it was homicide or undetermined, because the options are natural causes or something to that effect, or suicide, etc. But there is no legal definition for murder or manslaughter implicit in that by necessity. They also, in the same line, I mean, they continued to push, as you know, this sort of straw man narrative, Floyd perfect. And we talked about it on Sunday, this hagiographic treatment of George Floyd. They even said he never resisted. They said that he saw that car and it looked like a cage.
And they said, and I thought it was disingenuous, not to use the word bad faith or dishonest. It was just disingenuous. He didn't resist, but he didn't assist, or something. I think they said something along those lines. It was relatively catchy. It stuck with me in terms of how strawman and mischaracterizing of the situation it was. And I think Nelson did a good job showing. Nelson's best job in all of this, and his strongest argument, was that the 9-minute video looks very bad. I mean, it looks bad, and it still has probably conditioned the way I'll always see this. But you have to see it from the full perspective, which includes the 16 minutes prior, what they played over and over again from different angles, to show what they meant by not resisting was quite resisting. There was a lot of mixed messages, things being said by George that can explain why Chauvin was acting the way he was, which could not be explained from that 9-minute video alone. So that he didn't resist but didn't assist, I thought would be enough that anyone would say, I can see with my own eyes that was not assisting, that was actively resisting.
And, picking on certain weak links of the defense about saying it wasn't use of force to put him to use the prone position, that a carbon monoxide could have been a cause of death. That was smart, but they couldn't restrain themselves. They said, that's not common sense. That's nonsense. But then they said, suggesting heart disease killed him was nonsense. Suggesting he could have OD'd was nonsense. Well, that's nonsense themselves, making that argument. So they analogized things that didn't fit and discredited themselves in the process. By contrast, I thought the best aspect of Nelson's defense, now he did the same lame, thank you for being here, all these defense lawyers do that. You open up and you grab them. I'm going to be given a little mini lesson on closing arguments this week for our locals board, Viva, barneslaw.locals.com, and we'll explain, what could have been here. That both sides could have done so much better. But what his whole identity in this case is, I'm the calm guy. I'm the fact guy. I'm the law guy. He even went out of his way to say, look, I could argue certain things, and I'm not going to argue because I see the evidence that rebuts that and refutes that. So he has pitched himself to the jury as I'm just the technical police report guy here to give you just the facts, like a Dragnet TV show. And so that may work. That works with a certain group of jurors. He knows that jury better than I do. So we'll see. I'm not personally a big fan of that style. I prefer a much more dramatic style because I think it works more often than not. But putting that aside, the best part was in the middle when he played 4 different videos from every body camera and other people that were present of the 16-minute lead up to what happened. Whereas the prosecution tried to misrepresent that they just came up to Floyd's door pointing a gun at him. That isn't what happened, but he misrepresented that. And then they skipped forward and they just kept showing the same photo over and over again. Chauvin on Floyd, Chauvin on Floyd, Chauvin on Floyd. That's it. Look at 4 seconds, ignore the rest. By contrast, Nelson went through and showed from all 4 body cameras what they were experiencing. And he also had some great subtle, I'll get into the subtle, smart maneuvers he made about perspective. But just that aspect was the most effective because you just see how 2 things you see over and over and over again, that time period where Floyd is just resisting so effectively that 4 officers can't even get him to sit in the back of a squad car. And they can't force it upon him, that they're totally unsuccessful, that he's too strong, too powerful, too resistant for that. And they hear Floyd making a lot of statements that explain why Chauvin didn't interpret his statements as distress later on. And the jury got to hear it. Him saying, I can't breathe, I can't breathe, I can't breathe, I can't, while he's in the back of the car that has nothing to do with the prone position. And they heard that 4 times repeated over and over.
One thing actually that Blackwell said, and it's the shame about not being able to respond to the response. And actually, let me ask this question first, because prosecution opens up, defense responds, prosecution can reply. Now I understand that that's the procedure. I would imagine that had the prosecution in its response added something that was neither in their opening remarks nor in Nelson's response, Nelson could have asked to respond. Is that what? So what would prevent the prosecution, who knows they get to end? What would prevent them from not saying something in opening that Nelson couldn't respond to and then adding it in closing when they could have mentioned it in the beginning so that Nelson could have responded to it?
Theoretically, you can argue upon occasion that they're limited by the scope of the response of the closing from the defense. But the main reason the prosecution is given the rebuttal right is because they have the burden of proof. So the theory is that they can bifurcate that way if they want and not be limited by what the defense presents. That depends on which court and which state you're in as to what the rules are.
Okay, so setting aside the procedure of the response, the whatever, you know what I'm saying. What I noticed is that Blackwell, at the end, in responding to one of the defenses, said, as relates to one cause of death, it would be preceded by a headache. And here we didn't have George Floyd complaining about a headache, where 2 minutes earlier they were saying George Floyd was complaining about hurting everywhere to show that what they were doing was causing the direct harm to Floyd. So they were, in my mind, you couldn't respond to it because the defense couldn't respond. But on the one hand, they said George Floyd was complaining about hurting everywhere because he said, my back, my neck, it hurt everywhere. And they brought that up to illustrate the harm, the pain that Chauvin was causing him. And at the same time said he wasn't complaining about a headache. So what the defense is hypothesizing as a potential cause of death couldn't be the case because he didn't complain about a headache. So again, that didn't fly. They didn't get to respond to it, but that's the nature of the beast.
And I thought that they spent a little bit too much time in the rebuttal. My brother taught me when I was a kid for debate, he who frames the issues, he who defines the terms wins the debate. Never let the other side define the terms. So I would never in rebuttal focus on responding to the defense. I may be I would tell my own story, frame the issues, define the terms, and not worry about responding piece by piece, particularly like he ended up looking really bad when he tried to argue that he didn't ingest any pills, that he was just chewing gum the whole time. And yeah, a pill ended up in the squad car. So what?
With his saliva on it. That's straw manning over some damning fact. I say potentially damning facts to the point where it could cause one to lose credibility.
Yes, there's no need to don't look. That's a weakness. It's a reverse. I have a bunch of Sun Tzu principles that I use, and it's a reverse of one of Sun Tzu always said to defeat what is strong, attack what is weak. I always say the opposite too is true, which is if you have something is weak, remember what is strong. Talk about what is strong. Don't talk about what is weak. Trump usually understands this well. It's why he did well in a lot of political debates. If he was weak on something, he didn't talk about it. He talked about something that was strong for him. So I thought that was a limitation. But the best part of Nelson's defense was going through. Maybe the stylistic thing works. That may have been a tactical choice. I don't know. Maybe it's just his persona. I do think the judge prefers it dramatically, given the judge's hostility to Blackwell. But I think compared to Nelson, who's mostly had most of his objections sustained, et cetera. So that may be part of the choice. And then the other component with that, and in fact, Chauvin waived his right to a jury trial on any sentencing enhancements because they think that the judge likes him so much, they're much better off with the judge than a jury on that aspect of the case. And they're probably right. And so maybe that's also where Nelson's approach is coming from. And again, it can work with a certain kind of juror. Like there was a lot of people on our locals. We had a live chat open during the closing argument, and you're definitely right about that. I just stepped in a little bit for people that were commenting live on a live stream. That doesn't work. So I think in the future, we will just do live chats when there's something, because it's just annoying as crap when they interrupt it and all the rest.
Yeah, and you can't, and then you talk over another point when you're trying to make a point. One thing I just want to clarify for everyone, and Robert, correct me if I'm wrong, if you understand this better than I do. The issue of the oxygen and the carbon monoxide. I thought bringing up the carbon monoxide as a possibility was weak because I think it's so far-fetched that it's not even worth raising as a reasonable doubt. It seems like a stretch of an argument which undermines the good ones. Then I thought maybe the reason why Nelson brought it up was because it forced the prosecution to say couldn't have been carbon monoxide because he had 98% oxygen in his blood, which then the defense would say, well, look, he couldn't have died of asphyxia because he had 98% oxygen in his blood. And I see a lot of people saying that. And I think people have to understand, this is my understanding of why that doesn't prove what people think it does, is their argument, the prosecution being carbon monoxide could not have played a role, is that after they tried to administer and reoxygenate, they successfully reoxygenated the blood to 98%. Had it been carbon monoxide poisoning, the argument is that reoxygenating the blood would not have been able to bring the blood oxygen back up to 98%, even if he were dead. So that is my understanding of it. So what I thought it might have proved, it doesn't actually prove it. And if anyone in the chat knows if this is the case or not, but Robert, that's my understanding, is that the 98% oxygen in his blood does not actually prove that he could not have been asphyxiated as per the prosecution's theory. He was reoxygenated afterwards, which could not have been the case had carbon monoxide played a role. Is that about right?
I mean, it's to the extent of my scientific understanding, which is limited in this category. Yes. And what was interesting is Nelson used that as an example. He's like, I could have said that 98% means he couldn't have been asphyxiated. But I know because of this other evidence, which relates to what you're talking about, that isn't the case. But it also, because that other evidence also undermines some other theories the prosecution had. And he was fascinating. He used it as an example to say, look, I'm not just up here making any arguments. That if I don't think an argument has an evidentiary basis, a basis in reason, then I'm not going to make it. And then let me give you an example of that. You may even be thinking this, but here's to enhance his trustworthiness. He's also telling, in my view of closing arguments, it came up during the live chat, is that most closing arguments are giving ammunition to your side to argue back in the jury room against everyone else. It's often not to persuade people because usually by this stage of the case, they have already made up their mind. Now, this case is kind of unique. They may not have because of the massive gap between what they thought was true coming into the case and what was proven at trial. But I think that's often the case. And that may be an example of that. Nelson may have been thinking, I don't want people going in and making the carbon monoxide argument because it kind of fell apart for different reasons. And the 98%, and maybe that's the whole reason he had it all along, just to say, look, my guy was so thorough, he looked at every possibility. And when we looked at all the evidence, okay, this wasn't part of it. And we'll tell you why, but it's so he makes sure that people arguing on his side know, don't make that argument because here's the rebuttal that's coming. Make this argument instead.
And people are saying in the chat, and it's another thing that I had thought about is, can you reoxygenate the blood that's not circulating because the individual is deceased? People in the chat are saying you can't. And I'm wondering if that's going to be if that is sort of indirectly part of the evidence that was administered, because I was thinking this, like, you can do CPR on someone who is dead and still, I think, in a way, mechanically circulate the blood. I don't know how long you can do that for afterwards, and I don't know that you can re-oxygenate blood afterwards. But again, like, these are things that I know are well beyond my comprehension scientifically, and I don't think we need to get into it.
And they will be for the jury too. I mean, the bigger risk with the carbon monoxide is they shouldn't have put his face next to the exhaust.
And that's what Blackwell said in response. Is like, even if that were the case, in their custody and they're responsible regardless. But one thing that I noticed they kept doing, I forget if it was Blackwell, I think, who said it. Is that what a reasonable officer would do? And he said it a few times, and I don't like not hypothetical. What's the word? Someone help me. Rhetorical questions. I don't like rhetorical questions in general. They can backfire. They're arguably condescending or a little antagonistic. And especially when, is that what a reasonable officer would do, as your sole retort to the 2 hours Nelson just explained of walking you through why he thinks Chauvin's response was that which a reasonable officer would have, the way a reasonable officer would have responded. Nelson broke it down pretty thoroughly and pretty convincingly, even if you hate Chauvin and hate everything he did, is he went through the gradients of force. He went through the reasons for why there was the 3.5 minutes where he wasn't doing anything, played the four angles back, all four angles, and you hear the cops saying things which are not necessarily are not indicative of police who want to go out and commit an assault, a felonious assault. And at one point, Nelson said, look, they're recording. They know their body cams are on. They know they're being recorded. And what you can hear in the recording does not necessarily correlate to cold-blooded murder, what everyone thought, having seen the first video.
I mean, they beg him to stay in. They say they'll roll down the windows. They'll say they'll sit in the back with him. That's the mind. And when they try to make a big deal of Chauvin saying, if you're breathing, if you're talking, you're breathing. But that, of course, is a commonly believed thing. But when you actually hear it, I understood why they didn't play the video of it. It's not an aggressive, vicious tone. It's more, look, no, this is not an issue. That kind of tone. So they don't have the angry language. They don't have anything vile or vicious. And when you show that whole time period leading up to it, you see frustration, you see exhaustion. Also, you see, for example, Floyd seemed to respond. Either Floyd was experiencing problems long before he was in the prone position, or he was repeatedly, flagrantly lying the whole time period up to the time he's on the ground. Those are the only two alternatives. So that's the big problem for the prosecution's case, why they tried to hide the very body cam evidence that Nelson played over and over and over and over. And he got away with it by saying, let's look at this perspective. Let's look at this. That was a smart move. The other subtle smart move he did is he was kind of anticipating this appeal to the mob. Hey, be the mob. The mob couldn't get justice, so you get justice for him today. By saying, it's unique here when we learn about both perception and perspective. And he used the example of him not being able to see certain things throughout the trial because of the unusual layout of the courtroom. And then he said, let's look at some of these perceptions and perspectives. And it was good. He was like, the prosecution really wants you to see the world through the fireworker who didn't know what was going on, it turns out. Through the MMA fighter who didn't know what was going on, as it turns out. Through aspects of the crowd who didn't know what was going on. And then he contrasted it with all the people in the crowd complaining about Floyd, including the older African-American man, a younger African-American kid. They're like, oh my goodness, he's fighting with him again. Oh my, he's doing it again. What is he doing? Why won't he just get in the car? So they were interpreting him as not only being resisting, but not being straightforward and forthright. And so it was a very effective. And then he used that to bridge into the four officers' body cam, say, listen to them. Look at what they're going through. And they think they got him in a control position, and intelligently he hammered on one of the big mistakes, in my view, of the prosecution, that Floyd was already dead by the time that his end of resistance was when he died, which means anything after that can't be excessive force unless you believe that there is an affirmative duty to the degree of criminal intent, if you don't perform it, to immediately stop and perform CPR on him. The big problem there is, one, a bunch of the government's own witnesses said that there's risks of trying to do that in that context. And then the biggest problem is the paramedics didn't do it. The paramedics showed up and said the crowd's a problem. and we're pulling out of here before we do anything.
Do you remember actually day one? It might not have been day one. It was close to day one when we did the stream on this. And we said, what the person coming out of the ambulance was, it looked like a federal officer and not a paramedic. And we were saying at the time, why would that be the case? And the theory was that they knew he was already deceased and this was for crowd control. Now having seen everything and having heard the videos, and now that all the evidence quite literally has come out, you know, it makes sense. Where even the paramedics said, we're going to move because we don't like the situation. And whether or not it's too late at that point, it certainly lends a little bit of, it certainly creates reasonable doubt as to whether or not the intention, whether or not it was excessive force in the first place, or whether or not this was, you know, you can disagree with the police protocol, but whether or not this was within the realm of reasonable police behavior to the point where you don't even have the excessive force in the first place to get to any of the other charges.
Exactly. And I think, and what Nelson did well is he tied in that intentional unlawful language to say there has to be a subjective and objective element. It was a sophisticated pitch. It's why the prosecution was nervous because, I mean, but my view is jurors interpret jury instructions however they want. So they impose their own moral narrative on the case, and down deep there, and, you know, beyond reasonable doubt sounds great. Down deep that if they think someone's guilty, they convict. Even if they think, well, by a preponderance, you know, normal people just don't think that way. Once they're at 51%, they're at 100%. For most people, there's a few people who can really discipline their mind in terms of probability, but that's not the normal human being. And so fundamentally, when the way he defined intent, he did a good job of saying, did he think that what he was doing was excessive force? And if you were an officer and you'd witnessed this, he also did a brilliant little subtle move. He redefined Chauvin as a reasonable officer. He made the trial. Chauvin isn't on trial. A reasonable officer's on trial. The police are on trial. And if you were, and what do you want from that officer? And it's a smart, you know, reptile survival move, which I didn't realize this book cost like $7,000. So it's look up the idea somewhere else. I didn't realize I paid that for it. It is a great book, but $7,000 is a little pricey.
No, hold on. Which book is $7,000?
Reptile.
Is it a limited edition signed version with a $1,000 bill in it or something?
They just don't let people see it for less than $7,000.
that is interesting marketing.
Yes, it is. It is.
Okay, there was something else that I had taken a note about. Someone had said that there was vandalism on the expert's house. I hadn't heard about that.
Oh, they used a force expert. So, I mean, this is where this case gets crazier and crazier. They left a pig's head with pig blood on his front door, thanking him for his service in the case.
Yep, that is.
And that news the jury may have heard of that news because it broke before they went in today.
Well, okay, I mean, I don't. It's a world in which we're living where, you know, it's one thing to have media publicized, hyped up trials. It's another thing to have.
I mean, they want media mob justice. That's what this is. Yeah. Okay,
now there was something that Nelson had talked. He went through the gradients of what a reasonable officer would do, played all the angles.
He did very well. Redefined the perspective to not focus through Chauvin's eyes, but what a reasonable officer would do. Showed all the craziness of Floyd, showed him saying over and over again. Also, that some of the timing of Floyd's statements. I mean, like what would happen is he would be chilled for a second, and then somebody in the crowd would say something like he's having a heart, and he would say, "Yeah, I can't breathe," and he would pick it up again. That when I saw that, I was like, either he was lying all the way through, which means it's not unreasonable for them to think he's lying again just a few minutes later when he says he can't breathe, or he was having a problem long before he got on the ground, which means the prone position didn't cause it. They did a good job. Nelson did a good job of hammering that the prone position almost never causes death based on the studies. The prosecutor tried to be tricky again. They did this a lot. They said, everybody knows there's a risk with a prone position. Yes, a very tiny risk. He didn't mention that part. And his only evidence for intent was basically that. And then otherwise saying everybody was telling Chauvin And but that had already been discredited by that point because people are screaming blood choke at him. That's not happening. Breathing choke and neck choke. That's not happening. So people were screaming things that weren't true at him. And in his interpretation of the crowd, if it was so unreasonable, why did paramedics come to the exact same conclusion when they showed up? And so, I mean, that's the problem. And he also made a mistake in rebuttal. Always be careful what photos you show. They picked one of the crowd. And, the prosecutor, Blackwell, was trying to, it's a wonderful, multi-diverse, beautiful family kind of crowd. But he picked the photo where the MMA guy looks like he has blood red eyes and he's about to bull strike Chauvin. So I was like, man, you got to be careful which images, because he's the guy that stands out. Like, wow, that guy does look crazy and mad.
Well, and Nelson did a good job of saying, you're going by the video. Chauvin thought the situation was such that it warranted pulling out pepper spray, that he was startled that there was someone behind him. Look, that
happens exactly when the last breath happens. It was smart. It's like, well, why doesn't he immediately flip him over and give him help? Because he's distracted by the crowd. He's having to show him this. He's trying to back him off. And again, they think paramedics will be there any second because they called paramedics almost right away. It was one of the key facts that were excluded. It's like, okay, they're trying to kill the guy, but they called paramedics as soon as he was on the ground. And normally they'd be there a little bit sooner, and they weren't because of problems beyond their control. So that's where once the whole story is told, going back to Nelson's opening statement, this case isn't about 9.5 minutes. It's about 25 minutes plus. Then in that context, it's very hard to see intent, and it's very hard to see unreasonable force. It's hard to see. And then the causation is based on the medical testimony. And there, if the prosecution had, just conceded the effect of the cardiac arrest, the heart problem being a problem, conceded the fact that the OD was a contributor, but just said the tipping factor was the failure to give aid, for example, or the tipping factor was putting him in a prone position for that length of time when body pressure, then they would have been better off. But they made that argument only partially in close. And then they would come right back to saying it's ridiculous, it's nonsense to think this could cause it. They took a position they didn't have to take.
That was another thing. He had a strong heart. That the certain scientific aspects of the heart, which are also common sense, and glossing over it. It was a strong heart. It couldn't have had anything to do with it. Now, the reality, though, is one of the weaknesses for the defense is, but the judge made it clear, is that it had to be a substantial cause. So not just any connection, a substantial cause. What Chauvin did had to be...
Couldn't be just a contributing factor. Has to be, and how jurors interpret that. Here was the key. If the prosecutors would have got ahead of the curve from opening and throughout evidentiary presentation and in close, made it clear that they were conceding the other factors were contributing factors, but just saying the tipping factor. What's a substantial factor? It's the tipping factor. That the tipping factor was the failure to give aid after he was no longer breathing and put him in a prone position for that length of time with that pressure on his body. If they had that's what caused the death, or was the tipping factor given the conditions he previously had. And that's why it doesn't happen often, but it was going to happen to George Floyd. And they knew it was a risk of occurring. Then they would have been ahead of the curve. But by saying over and over again, you can exclude these causes, the jury, how do they interpret substantial cause? Again, they just narrate these things normally. So they've preconditioned the jury to believe it has to be all or nothing. So by saying that the way they went about it, it limited the effectiveness of that jury instruction could have provided the prosecution.
It's very interesting, actually. It's good point. The defense went straight at the tape and tore it down, just as in the Rodney King trial comment. One thing for certain, the defense went through it, played it all from different angles and over again. Even though I was listening to one pundit, and I call him a spin pundit. It was, I don't know who the lawyer was, but it was on NBC or something. In the pause was saying, why are they showing this video if the defense, this is not going to help the defense, this is going to hurt them? And I was thinking, that's nice spin. But the reason why they showed it in all its grit and in all its unedited truthfulness is because it does set up. It doesn't make anyone look good, but it does set up the context. The thing is, it doesn't make them look worse than the 9-minute video. It actually attenuates how bad the 9-minute video looks by playing it over and over again from all the different angles, and you get the entire global context.
Especially when he's on the ground and he's just kicking, which they pretended was a breath reaction. Doesn't look that way. And at a minimum, when you get to issues of intent, it's like, this is what he's witnessing. The guy's totally out of control. says he wants to lay on the ground over and over and over again. Put him on the ground. What does he do? He starts kicking. Nobody's on him until the kicking occurs. Then they get on him. And so in that context, was it patently unreasonable? The other factor is they're trying to measure someone's judgments in microseconds. And so that at some point, if I was a cop, I would be terrified of a guilty verdict in this case. What if I saw the evidence? So I'd be like, wow, every second of every decision I ever make, either my life's in danger, someone else's life's in danger, and I make a single mistake in a nanosecond, I go to prison for 40 years. I think that would be a little nerve-wracking. And that's why they never showed the whole video. That's why they never, and it shows you what these people think, that they haven't really reviewed all the evidence, or they've reviewed it from a perspective of just pro-prosecution.
Modema Rose says the level of Chauvin's responsibility is equal by measure of Floyd's culpability. If I understand
that, but for Floyd doing what he did, he's not on the ground. So it's not, doesn't mean he deserved to die or anything like that. It just means the reason why the police didn't say, screw you, we're going to throw you on the ground for kicks and giggles.
And not just that, it is not to say that because Floyd had done something wrong, Chauvin gets to do something wrong. It's the question is, why was Chauvin doing what he's doing? In the 9-minute video, it doesn't look like there's any potential justification. And this, again, raising reasonable doubt. From the original 9-minute video, did not look like there was anything that could have ever justified or warranted or explained how it got to that situation. Now you have 16 minutes explaining how it got there. Agree or disagree with that's where it should have gone is another issue. And then agree or disagree that what was done was in fact the cause of death or the substantial cause of death is another issue. But it adds a context that to some could raise a reasonable doubt, at the very least, to explain why Chauvin was using that level of force to potentially make it not excessive.
After these closing arguments, if this case is tried anywhere but Minneapolis or a big liberal democratic city, he gets acquitted. I have no doubt about that now. So, the guy in the San Francisco case, which pulled out a taser, he pulled out a gun, thought it was a taser, similar to the Minneapolis case. He went to a LA jury, and ultimately, I forget what happened. I thought there was an acquittal in that case. So, and there have been acquittals even in those cases. So, again, the Rodney King case that the super chatter brought up looked a lot worse. 8 cops sitting around beating a guy, and what is they slow mode Rodney King's reactions. That King refused to stay down. And so that's what gave them a plausible defense. Now, they also spoke witnesses in their own defense, were very effective. And now it didn't matter because they were later charged with federal charges anyway. Welcome to our system of, double jeopardy, where double jeopardy doesn't matter in certain contexts. But that's an example. And this is far less egregious than Rodney. There's no comparison in my view. Rodney King was much more brutal. And then when you add in the context that most cops are being trained that prone restraint is the lowest level of force, and that for many of them, they don't even think of it as force. They think of it as constraint. Then and I didn't think the prosecution, other than they said some studies exist that contradict this. And, they didn't explain if putting Floyd in that position would cause anybody to die, like their lead expert said, then why does almost nobody ever die from that? And every study done again and again and again, nobody ever dies from that. So studies that have done twice as much weight for twice as long, nobody was seriously harmed in it. How does that happen? So they really never had a good answer for that beyond, hey, we have the biggest experts. It was, a motion appeal to authority and some catchphrases with some good visuals. So they checked off the list. It just wasn't an effective story from a narrational perspective, didn't have thematic unity in an effective manner, and was factually questionable based on a wide range of claims that they made.
All right, let's see what we got here. Why is Chauvin being tried federally too? What's the difference between federal and Minnesota case?
Right now, he's only facing tax charges federally and on the state side. They can also tag him with civil rights criminal charges, which the Biden administration probably will if for any reason he's acquitted here.
All right, and here Joe Henry says, if there's a split verdict on the 3 counts, then later a mistrial is declared on appeal, would that throw out just the convictions or all 3?
Only the convictions.
Okay. What are some of the other questions that I had or that I thought the jury 4 reports we're going to find out soon in theory. What else was there that I had taken in terms of notes? No, I think that's it. I mean, if Nelson was fact-based, I think Nelson had to be, call it almost boring, but methodical in the facts, because you can't be emotional as the defense, because it's an ugly case to begin with, and you can't really go after it.
It's a stylistic contrast. He's trying to be a science lab high school teacher, and he's appealing to that part of the psychology of the jury. And there were people like that. There's IT people, engineering people, bankers. So there were people like that on the jury, and he again knows them better than we do. And if he's right about that, then his stylistic presentation is the right one. I still would have had stronger themes. Have some themes that they can stick in their head, a couple of visuals and themes. But the other thing he did was he basically told them, you need to go back and watch the whole videos. He's like, they've only shown bits and pieces throughout the trial. Now, what that is that's an invitation for them to spend all week looking at the case.
Now I'm just pulling up some chats that I have not read, but this is not a banned account, not about tonight. Robert, what else should we add? I mean, to this. So what do we expect to hear? We're not. Oh, sorry. One person corrected, I think. Yesterday you said that if they come back and they don't have a decision, the judge issues, what was the word? Says go back.
Allen charge.
So someone said that there's no Allen charge in Minnesota. I think I read that in a comment somewhere, but I'm not sure.
The Allen charge itself is a federal rule, but in the state proceedings, I guess he doesn't have to say go back, but they usually do. Just as a function, keep trying, keep trying, keep trying. So the Allen charge basically is the federal court system sort of codifying a principle that exists in every court I've ever been in. So it's possible Minnesota doesn't do that and says, oh, you're hung. Okay, we go home. But almost no judge does that. They have inherent discretion to say, go back and keep working on it. Go back and keep working at it. Especially this judge, I have a hard time him saying, oh, okay, you guys are deadlocked. Everybody go home. So it may not be legally required for him to do that like it is in the federal system and a lot of other states. But functionally, I can't imagine this judge won't do that.
All right. And if Mr. Chauvin had taken the stand, could he have addressed the question of systemic racism and calls for police reform?
Not real. None of that has come into the trial.
And now, at the end of the day, is it a mistake that the only person you didn't hear from is Chauvin? I mean,
I never would have put Chauvin on the stand. The people that want to acquit him don't want to hear from him, and the people that want to convict him want him on that stand so they can pick him apart. And this is especially as Nelson made more clear. Brilliant use of reasonable officer, because the other thing he did was basically he was able to plant in the juror's mind that Chauvin knew information that Chauvin probably did not know, but that was favorable because he kept saying a reasonable officer would know this, a reasonable officer would know this, a reasonable officer would know that. In fact, they were so agitated. That's why the prosecution demanded that they should be able to comment on Chauvin not testifying, because they're like, he's substituting the reasonable juror for Chauvin. He even said at one point Chauvin. And the judge was like, it's a reasonable inference. And he also was like, I'm not making that big of a mistake in a case. That's a guarantee reversible error risk. But it gives in a sense of how effective it was. And it's that who's on trial is a reasonable officer. And if you buy into Nelson's perception, and that was very well done.
All right. This question, we've answered this many times. There are certain things you're not allowed doing on YouTube, and that is one of them. Liberal Bolsheviks, the new left. Robert, your thoughts?
Yeah, I mean, to a certain degree, but it statism. So there's almost no difference between Soviet-style show trials and Nazi-style show trials. Go back to look at how they put the Reichstag people on trial. So that was one of the great historical false flags events in history. And you can watch some of the, for some of that kind of information, deep state and hush hush episodes at vivabarneslaw.locals.com, where we have a live chat going. A whole bunch of people have been talking all day, and probably will check in at some point this evening as well.
All right, and we're going to read John Medelsky says Chauvin should absolutely be punished. He is dangerous and has lost his humanity, but technicals are different. I get it. He should get something, though, because he didn't protect and serve.
He is anyway because of the tax charges. So, I mean, the guy's going to prison. He's already lost his job. He's done, got divorced. He's going to prison either way. He was willing to do a plea deal for 10 years. That's why I have no sympathy for the state in this case. It's a political trial, not a serious trial.
No sympathy for the state, but sympathy for the people who are, if the verdict doesn't go the way, there's no way that this can go that would subdue any unrest anyhow. But yeah, he could have had 10 years in jail. I mean, it's...
the risk is if they get a conviction across the board, they're going to keep doing this. So it will be an invite for media mob trials in the future. The January 6th people will be up next. My client Rittenhouse, they'll try to repeat the same thing. So that's why, even though I'm a critic of how I thought Chauvin responded, his default response to fear was force. And I didn't think that was the appropriate response under the circumstance, and had problems with it from that perspective. But I didn't see enough to get past reasonable doubt criminally, and the political consequence of this case is much more precarious than it started out as. And I don't like the precedent it would set from that perspective.
Greg Rankin says, Viva, you keep referring to your original view on the 9-minute video. Is your opinion based on the evidence in the trial or your initial reaction? My reaction was based on the original video, and I have learned as much as everyone else as to what came out during this trial. And it goes right back to something I said, and I took a little flack for in the comment section. I think he's guilty of something. I don't know what the array of charges that they could have otherwise brought without going for the 3 top charges, or without accepting a plea deal on some of the charges. I just think they went with an overcharge in this, which might come back to bite them in the butt, notwithstanding the felony murder case law in Minnesota, which itself may be a problem if it goes to appeal. So,
huge problem. I mean, hopefully this case might give it. I mean, if there's a conviction, hopefully there's an opportunity to fix that on appeal. It would be really scary if they vindicate that too. So you would have dangerous law on the books, and you have this precedent set that this is how you can legally lynch somebody. And I find both of those deeply problematic.
Oh, well, for not that chat was a humorous chat. Justin, Supreme Court Justice sold a book advanced for $2 million. I saw this. Who else? And Barr has sold a book also for many millions of dollars. In fairness, Clarence Thomas sold a book at one point. I didn't go to see how much or when, but it does. I don't know how a sitting Supreme Court justice sells a book for $2 million. I don't know how that can happen. At the very least, they should have to wait until they're off the bench.
I mean, it's the best legalized money laundering that exists. And there's just so many examples of it, and it's problematic. But yeah, the people that are commenting about how Barrett prejudged this case, it was a sign that she was not an appropriate person, in my view, for a judgeship. Period. I mean, as a lawyer, you should know better than to when you're going to be up in a political, high-profile position to comment on a case that hasn't yet gone to trial. But that gives you a sense for her instincts. She just assumed that the case was clearly guilt, even at that point where a lot of other information was out there, and it told her who she relied upon for sources of information, and it showed a lack of discretion at prejudging somebody's trial as a Supreme Court justice before the case. That was, other lawyers commenting, that's completely fair game, but not a Supreme Court justice who might preside over the case someday.
Yeah, the $2 million as a sitting judge shocked me. But to be fair, I'd have to see what the other judges got as well. Clarence Thomas. How did they get Chauvin on taxes? Arrived late. We didn't mention it now, but how did they get Chauvin on taxes?
He hasn't been filing returns in many years.
He's a cop. They do deductions at the source. What does he have to hide from the tax authority?
Exactly. Almost guarantee that goes down a corruption trail.
Rolf Peterson, BART officer Mazzoli went to tasing a resisting Oscar Grant, but mistakenly pulled his service gun and shot him. Due process found for involuntary manslaughter. Rep. Barbara Lee claims it was the popular lie.
Yeah, he ended up being convicted of something much lesser. That's the case I was referencing earlier, the California case. I think they made movies about it. And there was the big dispute was whether or not his explanation was truthful. People were saying, nah, he just made that up afterwards. But there was reason to believe he was being truthful. But it gives an example. I mean, cops rarely get convicted in general. And this case is just one of the it's less egregious than Rodney King. It's less egregious than the Diallo case out of New York. It's less egregious than the Grant case. So in that context, that this guy would be convicted for effectively a life sentence does seem disproportionate for broader public policy. Though they made that appeal too today in closing. They said, do this to send a message about excessive force, which was really, prosecutors are supposed to be very careful about that.
Okay, what else did we first of all, 9,369 people that I can see watching now, thumbs up and put a comment in there just to make things go a little haywire in the comment section. Let me check my notes and make sure I didn't forget anything. I think we covered everything from the closing arguments. Is there anything that you think we might have missed, Robert?
No, I think that covers it. I think stylistically, real weak for the most part from the prosecution. A gamble, tactical choice by the defense that may pay off. Substantively, very good from the defense. A few good points from the prosecutors. I thought some of the catchphrases were good. Appeal to the badge was good. Showing I thought the images they selected. Floyd as a baby, Floyd as a young student, and then showing Floyd as the adult, and then showing the knee on the back image over and over and over again. I think a dozen times, just like they did in opening. Was all smart. I thought that was good use of visuals. The chart for jury instructions was pretty good. I'll tell you that a lot of judges won't allow that because they think no, you can only quote and put up the jury instructions. You cannot try to create a demonstrative about the jury instructions. But state judges tend to be more flexible. But he defined felony murder in such a way that it didn't have the word intent in it. So it gives an idea. I mean, if you're going up on appeal in this case, that'd be another piece of evidence you'd use. That shows how risky this is. But I think as a whole, their real theme was lynch him for the community, was my view. Believe your eyes to believe the media's lies. Whatever prejudice you come in with, keep it. And the judge, by the way, only looked up real aggressively to all the jurors when he said, do not let public opinion influence your judgment in this case. And so it's clear the judge wants them to be an honest, fair jury. The two alternates have already been released. He talked to them behind the scenes. Sometimes the lawyers get to talk to the alternates, which can be great, but not always great. I had a case where two alternates, one talked, that one was like totally not guilty. Unfortunately, the rest of the jurors weren't thinking like that guy. So so it doesn't always help, but you get some interesting feedback. Other time you might find that something's going AWOL. Jurors go in 100 different directions. So I thought what Nelson did was give them a lot of material to argue with, a lot of material to review, a lot of material to think about, but he should have given his closing, in my view, should have given his closing argument in opening. There was almost nothing he said in closing that he could not have said in opening. And then he would have been way ahead of the curve with the jury. So they were pre-filtering, persuasion, pre-filtering, pre-framing the evidence through those eyes. He took a huge gamble by waiting. So that's the other risk he took. It's the craziness of the jury environment, the craziness of having jurors have already seen evidence and come to a judgment of the case that they're sitting in now judgment of, the craziness of the congresswoman and the riots and all of that, and this message from the prosecution and now the governor backing it up on TV, you better do what you're supposed to do for the community, against the defense lawyer saying just follow facts and law. And that leads you to reasonable doubt. And and uphold the legal system and do what just the facts and the law compel. And where we'll see which one wins out.
One thing someone had asked previously, and I had the same thought, the judge seemed to have interrupted Nelson when he was sort of in stride in his closing statement, but they had to break for lunch. There was nothing.
Yeah. In fact, he let him go 10 minutes long. There's some other judges who wouldn't. That was a tactical error, I thought, on his part. You should time your presentation. And this is where TV helps. You do a lot of TV interviews, you learn, okay, 30 seconds out, I got to get out. What's my out? And he should have had a little clock there to do that. I wasn't a big fan of how they stuck to the book. Now, Blackwell did much better not sticking to the written script and just talking to them. And Nelson, to a certain degree, did too. He clearly was very prepared and very organized. The first prosecutor, a little bit nervous. He does white-collar federal cases, so is what he used to do. Those guys are, they always stick to the book because they don't usually know the facts 9 times out of 10 themselves. But they're all little Yale boys and all the rest. But they're like the kind of people who founded the CIA, so that should tell you who they are. But and I thought tactically that wasn't as great as it could have been. I don't do that. I'll come up with a bunch of papers that are my exhibits. They're organized in a certain way, and I'm putting them on the Elmo and going boom, 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 boom. Or if I have a visual presentation, my guy knows when to go all the way through. But I just want to tell a story and keep connecting to the jury, because it's the one time you really find out in closing. If you step up and that jury leans forward and paying attention, you're in the game. If you step up and they're all like, don't care, don't take notes at any time, then it's like, time to settle this baby. So in the Snipes case, Snipes chose me to do the primary close, and I understood why as soon as I got up there, because during trial, the jury's over here, you really can't absorb what they're doing or process them. And apparently Nelson couldn't even see 4 of them. But I got up and all of them, 9 of them leaned forward. but leaned forward aggressive and were eager to hear. And I was like, oh, baby, we're in the game. So we'll see what this case is like.
All right. And there was one other question that I had. Oh, yeah. Someone had asked about waiving the jury for sentence enhancements.
Smart move. In most states and federal courts, sentencing enhancements are determined by the court anyway, though that's controversial for a range of reasons about whether it fits within the jury trial requirement under the Constitution. But so once he saw the judge had been sympathetic and Nelson had played well to him all trial, it made a lot more sense that if there's a conviction, you don't want that jury determining your sentencing enhancements when you have a judge who's game. So I think that that's why he waived only that part, has no impact on the rest of the trial.
I'm not your buddy guy says, hey, Viva, you missed both my super chats. Is it because I have a bad opinion? Please let me know because I greatly respect your opinion. Definitely not, unless it was an overt insult, abusive super chat. I didn't deliberately ignore it or I didn't deliberately not bring it up. If you can, put your comment back in. I'll do my best to get to it before we end. But no, I do not bring up things because I disagree with the substance. I specifically sometimes bring them up because I do disagree with the substance. Why was there no mention of anaphylactic shock? I suspect that is not...
I mean, there was. I mean, the prosecution came back to it repeatedly. That their point was that this was a form of that the way he reacted. I think that was the wording they used. It may have been different, but that the lack of oxygen, that he was showing signs of a seizure from that. Now, both sides sort of conceded that, and what the defense argued was that was in reaction to a heart attack, as opposed to being in reaction to lack of oxygen primarily. So it's really a causation factor. Both of them agree ultimately a heart attack killed him. They disagree with whether the lack of breathing triggered the heart attack or the heart attack triggered the breathing problem. So as I understand it. And so now I thought Nelson could have been more sarcastic at key points. He chose not to go that route. I think, again, he wants to be a by the book guy, stick with the facts guy, just being the presentation guy, the science teacher, the lab teacher in high school kind of guy. But like I would have hammered on a lot of crazy statements made by the state's experts in this case. But all he did instead was, it was brilliant use. He said, all of these medical people saying it's not even possible that his heart condition had anything to do with it. All these medical people saying this level of drugs in his system didn't have anything to do with it. Is that really credible? No, it's not. Big mistake by the prosecution.
All right, I don't see the chat from Not Your Buddy, but anyhow, so no.
Interesting name.
Yeah.
I wonder if you took any umbrage at, my name is Not Your Buddy.
Now, last question, and we'll wind it up on this. What's your prediction now that the closing arguments have gone through? Is it what it was before, or do you feel comfortable sharing your prediction? Okay.
Yeah, because my view is, I thought it came in 8-2 before trial, 8 conviction, 2 not guilty, 2 undecided. I think that's 8-4 now. But the question is, how many of those 8 could be shaken off their position because what they came in believing was disproven at trial? How committed are they to that position? Was this something that they just weren't going to budge, like most of the media, like a lot of people on the left? Or was this just something where they could really second guess what was taking place? My view is probably 1 or 2 did. We'll know soon. If they don't come back tomorrow, then it's probably a 6-6 split. And then the question is, there won't be holdouts for not guilty, in my view. There may be holdouts for guilty that may lead to a mistrial or a split verdict in the case. But I do think that they won't do like felony murder and not the lower counts. I mean, they'll make a laugh of the joke of the Minnesota criminal justice system for felony murder. I think they're much more likely to be, they know which is high and which is low by the way the judge presented it today. So if they compromise, it'll be second-degree manslaughter they compromise on.
All right. And I think a lot of people are thinking there might be a hung jury, and I may have mistaken in thinking acquittal. I may have mistaken in not appreciating the difference between acquittal and hung jury, and so everyone appreciates it. Hung jury means that they didn't all agree, and there could be a new trial, or there will be a new trial. Acquittal requires all 12 to agree on acquittal on all the charges. Yes. I think Nelson did a great job building the argument for the absence of excessive force. I do think, with the images, it may be hard to scrub those images out, but from a, maybe don't even call it objective, because everyone knows my initial reaction. Knowing my initial reaction, I think he did a good job raising what could be a reasonable doubt. It's, on the essential element that leads to all 3 or any of the 3 charges.
Precisely. And I think there's questions on intent, questions on causation. And so you combine those with the questions on with the questions on reasonableness of force, both objectively and subjectively, which he brilliantly, subtly included, then I think that, and I think he did a better tactical job in his closing of shifting perspectives, changing framing, how he evidentiarily structured. The only criticism would be lack of thematic unity and memorable catchphrases. Yeah. But otherwise, a very solid job, way above average for most criminal defense lawyers, in my view.
Especially since it was a proverbial literal David versus Goliath. This one guy who had to remain on his toes, sharp as attack for 3-4 weeks now. Yeah. And now some people saying the jury will convict because they do not want their homes and businesses burnt to the ground. Possibly. The flip side is
absolutely. But they know they're on trial, and man, the judge really hammered that today. The way he put it and the way he looked at him when he said it, don't let public opinion influence you. But is it realistic to expect that of a jury? Probably not. But that's why this jury could be a heroic jury. And the only heroism that can come from this jury, in my view, is not guilty verdicts. Whatever you even think of the underlying case, because it would be a sign that they were willing to make a decision based on what they believed was true, regardless of the consequences to them personally. So it would be a great testament to our legal system. That's the other reason why I want acquittals. I otherwise don't care too much about Derek Chauvin. Again, 17 prior complaints. Take it how you want. But a guilty verdict sends the wrong signal to some bad actors, and a not guilty verdict is a testament to the power of the democratization of the American jury, and for ordinary people to stand up against ridiculous pressure and do what they think is right, the consequences regardless.
Well, and I would respond what this person responded, Joe Carr's, the pressure to vote guilty because they fear the reprisals. Maxine Waters has made it clear, there's going to be reprisals and violence regardless. And so this might actually have the exact opposite effect, is you're going to do it anyhow. This is what we're going to do. And we're not going to care. We're not going to be intimidated. We'll see. Okay. Well, that was phenomenal. And we had to recap. If there's news, we'll stream. If there's news in between the week now, maybe we go live. Otherwise, Wednesday, we have a sidebar. Guest is not yet confirmed, but we have good guests on the, what is the word? On the bulletin? Whatever, on the card. So Wednesday sidebar is on. We'll send out the link sooner than later. Robert, let us out with something good in any event, and I'll thank everyone beforehand. Have the last word.
In most systems in most states around the world over the time of history, people like Derek Chauvin would have just been lynched. So the fact that we had a real trial where real evidence could be presented, where instructions on the law could be given, and where a jury yet may make the conscientious decision is a great testament to the American jury trial experiment, and shows a great improvement over most systems around the world. The mere fact of a trial mattered, and that by itself it is an achievement. We'll see if the jury takes it to the potentially heroic outcome that I think they can, but time will tell if they do.
All right. And with that said, everyone, see you on the interwebs. Robert, stick around. We'll say our proper goodbyes. Peace out, everyone.